Hi guys, I'm not sure where this shut off. So I can't tell by the front of the camera where this shut off. So I am going to, this is part 2 of Randazza versus Cox and the denial of a summary judgment. And it says that plaintiffs have not authenticated the purported emails between Cox and Dillon Energy CEO Martin Kane. Although plaintiffs attempted to authenticate Exhibit C, circumstantial evidence, there's a gap in the email chain. MJR at Randazza.com purportedly received the forward email from Matt.Bear at DillonEnergy.com, SavvyBroker at Yahoo.com, the email associated with Cox, sent to Dillon, CHP, MC at Verizon.net. Therefore, it is unclear how the person in control of the email address, Matt.Bear at DillonEnergy.com, came to be in possession of an email originally addressed to Dillon, CHP, MC at Verizon.net. Without some explanation of the gap in this email chain by someone with personal knowledge, there is insufficient circumstantial indicia of authenticity for the court to use this document. So I'm not sure where this shut off, so if I'm repeating this, then please forgive me, but this is important stuff. So basically, yeah, I know Mark will probably use my legal advice here, because, he apparently don't know this stuff, but if you folks have this situation, what you want to do is you would get like this Matt Bear person. He would have had to sign something and swear to it that how he got this email. So that would authenticate it, right? So say Martin Kane's the CEO of the company. He gave it to him because he was, wanting to entrap Crystal Cox and set her up for extortion, and then he could swear to that. Obviously, I'm being, because they're not going to admit their guilt. So basically, the idea is for you can't just submit an email to the court without authenticating it, even though that's what they've done to me. Forbes, the New York Times, all the courts across the land. This judge is saying that that is not proper. All right, so, yes, and it is unclear. How did this person get in control of the email? I mean, somebody just forwards an email and all these unrelated things, and Mark Randazza should know this stuff. All right, plaintiffs have not authenticated the text message screenshot in Exhibit A either. The screenshot purporting to be a text message exchange between Messrs. Randazza and Bernstein has not been authenticated because it does not have circumstantial indicia of authenticity. It is unclear which phone numbers sent or received the message, or to whom those phone numbers belonged when the screenshot was taken, or who took the screenshot. Without this type of supporting evidence, the court cannot consider the text message. So you guys have to authenticate your phone numbers, okay, best you can. So say, whatever information you get from the courts, probably why Mark was trying to get more of my phone records, you have to prove that that person owned that phone at that time. Okay, so otherwise it's just circumstantial evidence. Finally, Exhibit L, which is compiled listings made by the plaintiffs of the allegedly infringing domain names, is not evidence, and no realistic effort has been made to render it authentic and worthy of evidentiary consideration. Administrative agency decisions. Okay. Certified copies of public records are self-authenticating when the copy is certified as correct by the custodian or another person authorized to make the certification. The WIPO administrative decision contained in Exhibit F has not been properly authenticated. Although Mr. Randazza attests that it is true and correct copy of the WIPO administrative panel decision, he lacks personal knowledge of the authenticity of this document because he did not write it, sign it, use it, or see others do it. It has not been established as a self-authenticating document because it is not accompanied by a certification completed by the custodian or another person authorized to make the certification under WIPO policy. So basically, folks, you need to have someone, so he should have had Peter L. Michelson sign a certification that he truly and correctly wrote this, it was a WIPO decision, or somebody at WIPO that this was an official copy. So this is very good information for you to know. This judge is taking things seriously. Whereas like Judge Marco Hernandez, he just was all willy-nilly with it. The Ninth Circuit was willy-nilly with it, accusing me of a crime in a civil case without giving me due process. Okay? You cannot just put in evidence and tell the court that someone's guilty, and the court decides they're guilty, unless you know the judge or you control the judge, which rumor has it that Mark Randazza does control many judges. Clearly, he does not control this one. She's sassing us both. Okay. Oh, in my opinion. And it says, finally, regardless of whether the document is authenticated and admissible, the WIPO decision is not entitled to deference. All right, well, there you go. Okay, now he submitted a YouTube video as some sort of evidence that I was bad and improper, and I don't even remember what, I have so many videos online, I don't even remember what I said, but he took some part of the video out and said that I did something bad, and I don't even remember what it was. This is so long ago. Okay, Exhibit N is a transcript of a YouTube video. The single court, having addressed how to authenticate a YouTube video, albeit in a criminal context, found that videos from the online video network are self-authenticating as a certified domestic record of a regular conducted activity if their proponent satisfies the requirements of the business records hearsay exception. So, folks, be careful what you say on YouTube, because it can and will be used against you, but only if they authenticate it. Okay? To meet this exception, the evidence must be accompanied by a certification of their custodian or other qualified person that satisfies three requirements. A, that the records were made at or near the time by or from information transmuted by someone with knowledge. That they were kept in the course of a regular conducted activity of business, and that making the record was a regular practice of that activity. The transcript of the YouTube video contained in Exhibit N has not been properly authenticated. Although Mr. Randazza has attested it is true and correct, because he loves to do that, you know, which I call fraud on the court and perjury, but that's just in my opinion, of a transcript of a video posted on YouTube.com. He has not established that he is a person with knowledge who prepared the transcript, nor has he established when it was prepared and that it is complete and accurate. To the extent that the YouTube.com video itself is offered as evidence, it similarly has not been authenticated because plaintiffs have not pro-offered the certification of YouTube's custodian or other qualified person verifying that the page had been maintained as a business record in the course of regularly conducted business activities. Without this certification, the video has not been properly authenticated and cannot be considered. With this evidentiary limitations, the court now turns the merits of plaintiff's summary judgment. Okay, make sure this is still recording because it shut off on me earlier. Plaintiffs are not entitled to summary judgment on their claims. Summary judgment is appropriate when the pleadings, depositions, answers to the interrogations, I call them interrogations, interrogatories, they're interrogations to me, and admissions on file, together with the affidavits, if any, show there is no genuine issue as to any material fact, and that the movement is entitled to judgment as a matter of law. When evaluating the propriety of summary judgment, the court views all facts and draws all inference in the light most favorable to the non-moving party. If reasonable minds could differ on the material facts at issue, summary judgment is not appropriate because the purpose of summary judgment is to avoid unnecessary trials when the facts are undisputed. You know, like the facts are undisputed that Mark Randazza no longer has a case. The facts are undisputed that he has harmed me deliberately. How could he not know all of this stuff? And he's been using it to harass me for nearly 2 years. Okay, so that it cannot be disputed that Mark Randazza has done this to me. So it seems to me like he no longer has a case. He never had a case in the first place. He filed a SLAPP lawsuit against me, then helped make Nevada's SLAPP laws stronger. And so it seems to me that my counterclaims are very legit and that he has no leg to stand on and he had no right to sue me. He just has been harassing me. And this could happen to you, folks. These attorneys, like Mark Randazza, do this all the time. Okay, if reasonable minds could differ on the material facts at issue, summary judgment is not appropriate because the purpose of summary judgment is to avoid unnecessary trials when the facts are undisputed, and credibility determines the weighing of the evidence and the drawing of legitimate inference from the facts are jury functions, not those of a judge. Okay, Once the moving party satisfies Rule 56 by demonstrating the absence of any genuine issue of material fact, the burden shifts to the party resisting summary judgment to set forth specific facts showing that there is a genuine issue for trial. The non-moving party must do more than simply show that there is some metaphysical doubt as to the material facts. He must produce specific evidence through affidavits or admissible discovery material to show that there is a sufficient evidentiary basis on which a reasonable fact finder could find in his favor. Genuine, number one here, it's kind of indented and bolded. Genuine issues of material fact preclude summary judgment on plaintiff's claims 1 through 3 relating to violations of individual cyber piracy protection under 15 U.S.C. 8131. The Randazza's first, second, and third claims arising under 15 U.S.C. 8131 alleges that defendants' registration of the multiple domain names violates the provision that provides cyber piracy protection for individuals. In pertinent part, Section 8131 provides that any person who registers a domain name that consists of the name of another living person or a name substantially and confusingly similar thereto, without that person's consent, with the specific intent to profit from such name by selling the domain name for financial gain to that person or any third party, shall be liable in a civil action by that person. Or, you know, like the Glenn Beck name, you know, your attorney makes money, right? Like Mark Randazza made money on the case. The guy got to keep the domain name. You know, Mark Randazza is a hypocrite over and over and over. And did that guy register the name to profit? Did they have to prove that? Or did they just back off? I mean, read all the documents of all these cases, folks. Good stuff. To prevail under this theory, a plaintiff must show that the specific intent to profit existed at the time of the registration. The statute further provides a very limited exception for good faith registrants. A person who in good faith registers a domain name consisting of the name of another living person or a name substantially and confusingly similar, thereto shall not be liable under this paragraph if such name is used in, affiliated with, or related to a work of authorship protected under Title 17, including a work made for hire as defined in Section 10, Section 101 of Title 17. And if the person registering the domain name is the copyright owner or licensee of the work, the person intends to sell the domain name in conjunction with the lawful exploitation of the work, and such registration is not prohibited by a contract between the registrant and the named person. The exception under this subparagraph shall apply only to a civil action brought under paragraph 1 and shall in no manner limit the protections afforded under the Trademark Act of 1946, 15 U.S.C. 1051, or other provisions of federal and state law. Genuine issues of material fact preclude entry of judgment in the Randazza's favor on these first 3 cyber piracy claims. They have failed to show by admissible evidence that at the time the defendant registered domain names, there was a specific intent to profit by selling the domain names to plaintiff or a third party. At best, they have demonstrated only that Defendant Cox offered to sell Mr. Randazza a few of the domain names at some point after the domain name was registered. But that's not true. Mark Randazza ordered me to give him the names, said he'd give me $10-20 for my trouble, but I never ever offered to sell him the names. And when I put markrandazza.me here kitty kitty, that was a joke. And that wasn't sent to Mark Randazza, that was sent to the world. So, at any rate, I'll read that again. It says, at best, they have demonstrated only that Defendant Cox offered to sell Mr. Randazza a few of the names at some point after the domains were registered. This ex post action does not prove the specific intent to profit at the time the domains were purchased. Even if the court were to consider post-registration conduct, it still cannot infer intent at the time of registration because the evidence undermines that conclusion. The Randazza's own evidence suggests that Cox bought one domain name, to control the search and PR on her case, if Mr. Randazza represented her. This tends to show that Cox did not have a specific intent to profit at the time of the registration, creating a genuine dispute and precluding summary judgment on these claims. Number 2, genuine issues of material fact preclude summary judgment on claims 4 to 5 for cybersquatting under 15 U.S.C. 1125. The Randazza's 4th and 5th claims allege that defendants' registration of the domain name violates the provisions that prohibit cybersquatting. To prevail on a cybersquatting claim, a plaintiff must show that the defendant registered, trafficked in, or used the domain name is identically or confusingly similar to a protected mark owned by the plaintiff, and that the defendant acted with bad faith, intent to profit from that mark. Plaintiffs have failed to show by admissible evidence essential elements of these cybersquatting claims, precluding entry of judgment in their favor. Jennifer and Natalia Randazza's claims fail as a matter of law because they have not alleged or shown any fact to support common law trademarks in their personal names. So why did Mark Randazza is a trademark and intellectual property expert. He's a First Amendment expert. Why did he do this to his wife and child? Why did he drag them into this? Okay, I didn't. Mark did. Put a picture in Forbes? Yeah, I registered the domain name. As a joke, as a poking fun at Mark. I didn't write anything on it, and I didn't even tell anybody. I hadn't even made it public. How did he know? So he had a GoDaddy insider that told him I had the domain name. Okay? He violated my rights of privacy, seen that I had that domain name, and then he claims that I had a blog attacking his daughter and they have trademark violations and blah, blah, blah. Goes on NPR, and NPR is all dramatic. And what did you do in your darkest hour? Have you seen that interview? I mean, it's just, it's horrific. It's like this parody spoof movie. And these are real media, folks. This is NPR. This is Forbes. This is the New York Times. This is, you know, WIPO. And you got Mark Randazza filing amicuses to the 9th, and all these people just, why are they believing him? Why are they over and over accusing me of extortion? I mean, seriously, if you think I've extorted, you call the FBI, okay? Mark Randazza is an attorney. These judges, the 9th Circuit judges, aren't they supposed to protect you guys? I mean, why are these judges and all these attorneys just putting this in newspaper articles and in rulings and just using it just to ruin me and defame me and slander me because I'm exposing corruption and they want to discredit me and try to teach me a lesson? If I'm an extortionist and guilty of the felony crime of extortion, then why didn't they file criminal charges? Okay, why are they filing civil charges to get millions of dollars out of someone who doesn't have a dime? Yeah, so there's that. Okay. Goes on to say, okay, I won't read that one again. But anyway, they're not entitled to summary judgment because they didn't have a trademark. Why he brought him in is ridiculous. This is going to affect his daughter's life for the rest of her life. This is a record now. She was 3. Sick. Assuming Mr. Randazza could show a common law trademark in his name, he has not demonstrated defendants acted with bad faith intent to profit from that mark. To determine whether defendants acted in bad faith, the court considered the 9 non-exclusive factors outlined in 1125D1B. Number 1, the trademark or intellectual property rights of the defendants in the domain name. Number 2, the extent to which the domain name is the legal name of a person. Number 3, defendants' prior use of the domain name in connection with a bona fide offering of goods and services. Number 4, whether the defendant made a bona fide non-commercial fair use of the domain name. Number 5, defendant's intent to divert consumers from the mark owner's online location to a site accessible under the domain name that could harm the goodwill represented by the mark, either for commercial gain or with the intent to tarnish or disparage the mark, by creating a likelihood of confusion as to the source, sponsorship, affiliation, or endorsement of the site. You guys know there was no No confusion. I came right out and I called him all sorts of names, and I said I was his enemy, and I called war, and I put out my war cry, and I certainly was not trying to divert his good name and his traffic to my blog so that I could sell what? Sell my anti-corruption exposing who I thought was a dirty, corrupt, asshole, hypocritical attorney who had violated my constitutional rights and was interfering in my $10 million lawsuit where he was my attorney? Do I not have any rights? I'm the one that has the good case here against all of them. Again, my email, crystal@crystalcox.com, if you want to represent me to sue any of these parties. I am the injured party. Number 6, whether the defendant offered to transfer, sell, or otherwise assign the domain name to the mark owner of any third party for financial gain without having used or having an intent to use the domain name. So, if you've used the domain name for something else and then you sell it, I mean, it's my intellectual property. You know, he's trying to claim that I bought it just to extort him and then that's all it was ever for. No, the domain names were always to expose corruption and to and hopes that Mark Randazza cannot ever do what he did to me to anyone else. And even if I die tomorrow, I think that whoever Mark Randazza makes his victim again will have a lot more knowledge. And attorneys like him, when they read the Randazza versus Cox docket, the victims, even the pro se people, will have a pretty good place to go when this happens to them. Okay, so even if Mark's buddies follow through on their threats, and if I die tomorrow, this is still out there, and you folks know how to defend yourself against these asshole, hypocritical, above-the-law attorneys. Okay, number 7, whether the defendant provided false contact information when registering the domain name, whether the defendant registered multiple domain names which defendant knew were identical to or confusingly similar to marks of others that are distinctive at the time of registration of such domain names. Number 9, to the extent to which the trademark incorporated into the domain name is distinctive. I don't think you could confuse a domain name markrandazzaisanaasshole.com or markrandazza.sucks.com or randazza.legalgroups.sucks.com. No, I think it's markrandazzaislyingasshole.com. I don't think you could confuse these with his official, I'm selling First Amendment rights attorney stuff. Right, services or whatever. Yeah. Mr. Randazza has not shown by admissible evidence that the non-exhaustive factors balance in his favor. Although some factors may balance in his favor, such as 1 through 3, others arguably do not, such as 4 through 7, as plaintiffs have failed to prove an essential element of these claims, summary judgment is denied. Gee darn. Sorry about that. Okay, number 3. Genuine issues of material fact preclude summary judgment on Claim 6 for right of publicity under NRS 597.810. Plaintiff's 6th claim alleges that defendants' registration of the domain names containing the entirety or part of the Randazza's personal names violated their rights of publicity under Nevada law. NRS 597.810 prohibits any commercial use of the name, voice, signature, photograph, or likeliness of another by a person, firm, or corporation without first having obtained written consent for use. The statute defines commercial use as the use of the name, voice, signature, photograph, or likeliness of a person on or in any product, merchandise, or goods, or for the purposes of advertising, selling, or soliciting the purchase of any product, merchandise, goods, or services. Genuine issues of material fact also preclude entry of judgment in plaintiff's favor on this privacy claim. The Randazzas have failed to show by admissible evidence that defendants intended to advertise, sell, or solicit the purchase of any product, merchandise, goods, or services. Indeed, plaintiffs have offered no admissible evidence that tends to show any commercial use of their names. Thus, summary judgment is also denied. Let me read that again. Plaintiffs have offered no admissible evidence that tends to show any commercial use of their names. They knew this. So why did they get to sue, harass, bully depose people. They threaten to sue people that I've known, people that I've worked with. They've got my invoices from people who I've worked with. They've gotten wires. They've gotten my house address from my church. They've harassed people in my life. They've got my phone records. They've violated the rights of those I provide spiritual counsel to. They've tried to depose my exes. They've emailed people and just threatened to sue them if they don't give them what they want. All of this knowing full well as a cyber squatter expert, a trademark expert, a domain name expert, which is all on his letterheads from the past, and a First Amendment proponent, allegedly. And he does all of this opposite to me relentlessly for 2 years and has not let up. Liar, liar, pants on fire. All right. Number 3. No, we already read number 3. Okay. Number 4. Claim 7 for common law right of publicity is legally untenable. I like to do. All right. Plaintiff's 7th claim alleges that defendant's registration of the domain names containing the entirety or part of the Randazza's personal name violated their common law rights of publicity. Nevada has codified the right of publicity tort. Because the statute provides a complete and exclusive remedy for right of publicity torts, Nevada law, which certainly Randazza Legal Group should know, you know, that's the attorneys for Mark Randazza. There's no conflict of interest there, of course. Nevada law does not recognize a common law right of publicity. Oh, snap. Forgot to look that up. As Nevada law does not recognize this cause of action, plaintiffs have failed to state a viable claim under this legal theory, and this claim is dismissed with prejudice. Ha! Sorry. I thought that was a good one. Number 5. Genuine issues of material fact preclude summary judgment on Claim 8 for common law intrusion upon seclusion. Intrusion upon seclusion. The Randazza's 8th claim alleges that defendants' registration of 5 of the domain names containing the entirety or